we talked about causation. That's a part of having standing. To be able to get into court and sue, you've got to show there's a causation link between what those actors did, those multinational corporations, and what you are suffering as the plaintiff. And so that's hard to prove, as we discussed. There's also this notion of the relationship between the branches of government called the political question doctrine. So this worked against the plaintiffs here as well, in the sense that the argument is that you're bringing your claim to the court about climate change and its impacts, but you really ought to bring that to the legislature. We have the Clean Air Act. If you want to get relief for anything related to climate change, bring it under that statute. Congress should be taking care of this, not the courts. Likewise, climate change is an international issue. Take it down the hall to the executive branch, because climate change is an international diplomatic issue, and don't take those issues to the courts. That belongs in the executive branch. And this is the biggest challenge. The idea that we have legal authority to respond to disasters after they've happened. That's what FEMA does, right? The Federal Emergency Management Agency. You heard about that perhaps in relation to Hurricane Katrina, how its response was criticized as being inadequate. FEMA is useless to those who are about to become climate refugees. All FEMA could do would be to throw them some life preservers after they've been in the water. FEMA cannot say you're about to be hit by a train, meaning you're going to go underwater from climate change, and we'll pull you away from that brink of disaster. They can't do that. They're not authorized to act in this responding to a slow onset disaster. So that's where climate change law needs to change. We need to have some authorization to act when science is telling us that this will happen, and we can't simply watch people drown.